in the nation's capital, where former governor of Kaduna State, Nasir El-Rufai, has filed a 1 billion naira fundamental rights enforcement suit against the Independent Corrupt Practices and Other Related Offences Commission, ICPC, over the alleged unlawful search of his residence in Abuja. The former governor is challenging the validity of a search warrant issued on the 4th of February by the Magistrate Court of the FCT. In the originating motion on notice, the former governor sued ICPC as a first respondent, while the Chief Magistrate Court of the FCT, Abuja Magisterial District, the Inspector General of Police and Attorney General of the Federation were named as second to fourth respondents. In the suit, Nasir El-Rufai prayed the court to declare that the search warrant authorizing the search and seizure at his residence was invalid, null and void. He asked the court to declare that any evidence obtained is inadmissible in any proceedings against the applicant. Let's now bring in lawyer Tunji Abdulhamid, who joins me live on TVC News at 7 for more perspective on this. It's been a week, Mr. Abdulhamid, since this matter has been on. And now Nasir El-Rufai is filing a suit challenging the search of his residence. What do you make of this development?
Yeah, I think he's within his right to file a fundamental right if he believes his right has been infringed. So it depends on what he's alleging. He's talking about invalidity of the warrant or search warrant. Whether or not that will go through, it depends on the court. The court will determine that. So I don't want to go into the legality of that case, whether or not he will succeed, because the matter is still in court. It's within his right if he believes that a particular warrant that was used in searching his house was not validly issued, probably because some certain fundamental things are missing in it, probably if he believes so. But like I said, it's a matter of evidence before the court. The burden is on his head to prove that, to establish that before the court. So if the court is satisfied, he can that can go. But for me, what I found not too palatable to me is adding the magistrate in it. The magistrate is a judicial officer, and I'm not aware that you can sue a judicial officer. Why this for job done or for exercising his rights or performing his duty as prescribed by the Constitution. So if you are not satisfied with his judgment, you can appeal. But taking him to court and charge him alongside the police and the Attorney General is what I found that is not for me worrisome or questionable as far as I'm concerned. So because they are not susceptible to being charged to court for what they have done in the course of their duty. So he did not say.
Yes, Mr. El-Rufai himself also is actually a lawyer, but we'll wait to see how that pans out. But then, according to the Administration of Criminal Justice Act, is it stated that perhaps a suspect or someone whose home or property is to be searched has to be informed of the exact evidence or item that the prosecution is looking for?
Yeah, if you have a search warrant, you must specify what you think you are looking for in that house. In a way, you must be able to show before the court affidavits in support of that your application. That look, there are criminal things that you are expecting. You have to in particular, you are looking for this, you are looking for that, or you may generalize. If you generalize it, sometimes it is not enough. You must particularize it and let them know the particular things you are looking for. But if in the course of your search you find other incriminating evidence, you can pick them, because under our law, no matter how you obtain evidence before the court, the court will still look into it. So it does not matter how you obtain the evidence. So in that regard, well, like I said, I don't want to go into the matter, because one of the reliefs sought by him is to declare inadmissible all evidence obtained or exhibit obtained within his premises. That is, like I said, that again, the court will have to look at that. But I think, like I said, the general principle of our law is that even if an evidence is obtained illegally, no matter how it was obtained, once it's relevant, the court will rely on it. That's what I know about that.
So there is a lot that the court would, be talking about in this particular matter. And the former governor is suing for 1 billion naira. I know that, sometimes lawyers want to go all out just so that if it doesn't get to that, then you just understand that this is an intense and very severe matter. What do you make of that amount that he's pegged, the suit at? We often say that the best form of defense is to also attack. So yeah, I think he's trying to, he's been attacked from AFCC, ICPC, and DSS. So he wants to also bring his own attack so that there will be a battleground for them to dwell with. And again, probably he's trying to preempt the case before the court, so that the issue of admissibility of evidence will be a challenge when they go to court. It would say it's already before the court of fundamental right, challenging that particular evidence if at all they want to tender any of the evidence before the court. So for me, I think it's just using that mode of attack. The best form of attack or defense, sorry, is to attack. Tunji Abdulhamid,
that's what I think he's trying to do.
Lawyer, thank you so much for talking to us on TVC News at 7.
Thank you for having me. It's my pleasure to be with you. Thank you.